19.
And can you hear us now, Commissioner Holloway?
Yes, thank you.
You're welcome.
One.
Thank you. That's so quiet.
It's 9 o'clock and we're 2 commissioners short of having a quorum. I'll wait maybe another 5 minutes before we start.
How you doing? Happy New Year, everybody. This is the New Year,
That's true. We haven't seen you this year yet.
because I just got back.
Okay. Well, this is Australia, New Zealand trip?
Australia, New Zealand, Ghana, and Fiji.
Oh, around the world.
Yeah. Around the world in 44 days. 5 different time zone changes. That me.
What was that?
I really
You want to
enjoyed
switch can, so that the Reverend Gaines doesn't have to follow repeat together. Okay? But you don't have to. If you want to, you can switch.
Okay.
I don't give a shit.
Switch what?
2 o'clock.
I think you should switch. Okay. Reverend Gaines coming?
Oh.
Oh.
There's some country people. The grandmother said, don't put your person. You would scream at you if you did that. You know. Let's see. I'm not sure when we're. Update.
Okay, I think we'll get started. We do not have a quorum and can't do anything official, but we can take items that are not, that don't require a quorum for action. And first is, I think that we've had two individuals from the public who wish to address us. First up is
Calhoun. Calhoun.
Mr. Calhoun.
Also, I would like them to have accommodation, this building. Of my speaking,
You should have an accommodation.
accommodation to speak to the board.
You, that is granted, so you're free.
For a little more time.
Well, normally we're 5 minutes. Given where we are, we'll, as you go, we'll determine how much additional time we can allow you, okay?
That's fine.
Okay.
But also will you take effect that I'm disabled, most places give you accommodation.
We'll deal with it as it progresses. Let's go.
Thank you, sir. Okay. Now approach the board.
Can you pick it? Are people able to pick him up? Commissioner Hall, okay, go ahead.
Can I approach the board?
Yes.
Thank you. Good morning. Good morning to the board. And I'm putting y'all on Facebook to make sure y'all don't say I'm a bad person. Now, on my issue is this. Can you spell your name, sir?
Juan, Juan.
You are my notary, right?
Chair, can I?
Well, rather than posing a question to any of the staff, you can pose it to the chair or do a presentation. We won't not have a Q&A of anyone in the meeting, okay?
Okay, but then look to me to spoke the board of what I got going on in this investigation.
Okay, go ahead.
Did Ms. Fox give y'all the board of the investigation. It was asked by Art, for y'all to know about what this meeting's about.
As it relates to investigation, the staff undertakes those investigations. They report out in terms of what they find. To if it's necessary, then this commission will in fact take some action. But the way the process works and what is required by law, we don't have to necessarily approve or sign off on any of those things.
You're right, you don't. But my question, in the mix talking to Art is fire housing. He was the attorney representing me. He asked Ms. Fox to let the board know, give y'all a copy of the investigation. If y'all don't have a copy, how do I prove my issue?
Yeah, I would ask that what your issue
What's my issue?
issues
Okay,
are.
thank you.
Address those issues in terms of, and we will hear what you have to say.
Okay. I do the best I can because I'm disabled, but I'll do the best I can. In volume of investigation, a person had to file a complaint and send it to the board. And then after it was sent to the board, it goes to the respondent. The respondent has so many days to respond back. Is that correct?
Yes, there's a set procedure with timeline, deadlines, and those kinds of things.
Okay. I didn't get the chance to respond back to the allegation or my complaint. Every time I called Art with my attorney in fair housing, he had no answer to give me to this issue. And we went around and around for a long period of time. We had to contact Cynthia Fox and them to have the investigators to let me know what the respondent was. They told me that they didn't have none at the time. Also, in the midst of talking to Cynthia Fox, you had the investigator state something that I thought was rude, saying that something that, hey, I know Miss Fox is a good person. I'm a human being that was uncalled for. In the mix of that issue, I've dealt with this man before in another allegation. What y'all had in this board, y'all had Coach Cards kin to me on this board. Y'all had another person that run this board had to step down. All I ask anybody is this: if I go by the law, go by y'all's way y'all do, I should have the right to respond. And then when they made him respond back, she said, let them do the investigation. They didn't come back later on to me and tell me what the response was. Number two, they come back to me when I found out about the issue, saying I was a threat, or they scared of me. Nowhere in the law you got that on me. You got no criminal activity where I never was a threat. And I think that is a character. I can't go there and say something against you when you ain't got no proof of it. Due to this board, all I ever asked was if I file a complaint, I'll get an answer from the respondent. Give me the time to tell my evidence. And I didn't get that. Also, you had a person that notarized a piece of paper, a wrong address, which is a issue with the state government that looks over these people that notarize. Now, at the end of the day, why y'all have people file complaints if they don't have the right to respond back? And his investigators knows me. At the end of the day, I ain't never disrespect him. He didn't take what I had on paper. He took an allegation of medical record where he's done another investigation, which I could prove. Now I'm asking the board, or what I need to do. Do I need to file something to the state of a notary that the notary was messed up? Do I need to file something to the state to ask why I didn't have the right to answer to the allegation? At the end of the day, I'm a human being. And y'all, City Fox and all y'all their bosses. Now I'm pretty sure you're a smart man. I hope I do it. And I'm pretty sure you understand when a notary did not notarize something, it's a problem. That's why y'all have people to notarize stuff, take somebody to notarize something and bring it to y'all to make a legal document. If the notary's not right, it's not a legal document. Don't use me if I'm just, now, at the end of this, make myself short. In the last issue, this man never asked me for a disability paper. You had HUD that pays y'all money, go all over the state to try to get somebody to reopen their case. I had to send her a paper of my disability. No, in this investigation, nobody asked me no paperwork of disability. What they done was use me like I'm a threat. As a black man, not racial, black people go in white people's neighborhood all the time, late night. Police will pull them over. First thing white men say they scared of them. But you got no allegation of that. An investigator never ever one time I paid my rent by working in this woman's yard. I worked for this woman and paid my rent on this yard.
Okay, so yeah, I've allotted you twice the normal length of time. Is there any additional thing that you need to add or show? As I listened to you, your question was that you didn't see the respondent's response. A question regarding notary. What else? Is that it?
And another matter that was told to me that let them go back and investigate.
Well, the nature of what they're supposed to do is to investigate.
They didn't do it, sir.
Well, I understand your allegation is that they didn't investigate. Is there anything else you'd like to add?
Well, the one thing I'd like to add is this, sir. If they say they want to investigate, let them investigate. Why didn't they come back to Art as an attorney? This was some things we need to answer. And then we could have answered to that. They didn't do that. They closed and said I was a threat, basically. Or I was the woman was scared of me.
Okay. We understand what you said, and as I say, you know, we have processes and procedures for how things operate, and you know, so we've heard you.
Okay, thank you,
so-
thank you very much. If you got a process, I'm gonna go with this. If you got a process, if I'm disabled, you had Art there. Let me finish.
I understand.
So why-
you're repeating what you said before? So I
No, I'm trying to change it up a little bit. If you saying it's a process, I'm talking to you. You saying it's a process.
Yes.
What is the process? What is how many days did you take to answer to an allegation? You got a process. What is the process in time to me sign a complaint and have the right to answer to the get a response to the respondent?
I understand your question. Thank you. Thank you for your
But
presentation.
you want to answer that?
Not at this time. Owen.
But you understand what I'm saying?
I understand what I've written down the 4 things that you said, and
I'm very thankful for it, but at the end of the day, before I go.
Okay. Well, thank you for your.
Okay, but the thing I want to say this, sir. Thank you very much. But the allegations, you got process.
Mhm.
Why wouldn't I have the right to answer to the respondent?
Well, I understand. Thank you for that. we now do have a quorum, so I want to officially call this February 19th meeting of the Kentucky Commission on Human Rights to order. And we'll ask from the Executive Director confirmation of the quorum and confirmation of public notice.
We do have a quorum and public notice was sent.
Okay, well, thank you. And at this point is that we have, with Mr. Calhoun has spoken. We also have the privilege of having State Representative Kulkarni here, who has asked to address this body too. I don't know if you can still hear us or see us there. There
I'm
she
still
is.
here. Yes.
Yeah, okay. Well, thank you, and floor is now yours.
Thank you. I appreciate you all inviting me, and thanks to Juan when I saw him at the Black History celebration this month. I had a question about, I have a presentation. I don't know if there's time for it or if there's just sort of a question answer. I had presented this to the Commission on Race and Access to Opportunity in the legislature, relating to barriers for immigrant integration and kind of what I do in terms of my nonprofit, and then I have a brief run through of legislation. I don't know if there's one aspect of that that you all would rather hear, just given our limited time. So I just wanted to ask which part of that you all would want me to focus on.
Commissioners, which would you like?
Sorry.
Nobody's responding. I was just asking commissioners which of those they would like for you to address.
Okay.
Could you mention those one more time, please?
Yeah, I have I have a nonprofit called New Americans Initiative, and I presented as a legislator and as the executive director of that we basically focus on green card and citizenship, voter registration, and civic engagement. And I presented that to the Commission on Race and Access to Opportunity in the legislature previously. So I don't know if you are interested in some of those numbers and that data, or if you want a run through of current legislation impacting our immigrant and refugee communities that are currently proposed in the legislature.
I would say current legislature.
The latter.
The latter? Okay, perfect. So there's several bills, and I'll just, as a quick background, I'm an immigration attorney. I've had my own practice for over 15 years, and I've been a state legislator since 2019. So during the previous Trump administration. So a lot of the stuff that we're hearing about now with regard to immigration, still a signature issue for the administration, and having to do with expanding some of those same tactics. So one of the things that I'm sure people have heard about is the 287G agreements, which would essentially mandate cooperation between local law enforcement, and that includes sheriffs, it includes local police departments, it includes the state police. It includes, for instance, smaller police departments within Louisville, even if LMPD is not entering into these agreements. And so, in essence, it would require local law enforcement to cooperate with ICE, not just cooperate, but to assist them in immigration enforcement actions. These agreements were expanded during the previous Trump administration, but largely discontinued because of a lot of civil rights violations. There was racial profiling. There were a lot of allegations of just constitutional rights and due process erosions. So most jurisdictions that entered those chose not to renew them or have terminated them. So as of January 1st of 2025, there were 0 287G agreements in Kentucky. And as of, I believe, February 13th, there are 30 jurisdictions, and that includes detention facilities, it includes local police and sheriff's offices in a range of counties. And I'm happy to share that information with you. The idea behind expanding this is, especially in places like Kentucky, where there aren't a lot of immigration enforcement agents because there, historically hasn't been a huge immigrant population. But that is all expanding. There's no money allocated in these bills on the state level. There's just sort of this understanding or promise that the federal government will provide will provide funding. And of course, they have $80 billion or so to work with for detention, apprehension, and removal operations. So how that is flowing to these jurisdictions is going to depend on the individual contract. There is a bill in the Senate as the primary sponsor, Senator Philip Wheeler, and that would again require all local law enforcement and state police to enter into these agreements. So would not leave any kind of discretion to the local jurisdiction. It would mandate entering into this task force model program where they would accompany immigration and federal agents in apprehending individuals, whether they know what the status is or not. It's unclear about the training that local law enforcement would receive in understanding what documents they're supposed to be looking at. How do you figure out who is under what status? There's we don't have time to get into kind of like immigration 101, but there's a variety of different statuses individuals can hold, from temporary worker to green card holder to people that were paroled for humanitarian reasons by our government. So that's one bill in the Senate. House Bill 47 is a similar bill that's been filed in the House. The primary sponsor is Representative TJ Roberts. And again, it would mandate cooperation and this task force model contract with ICE. There's also a bill, House Bill 36, I believe. House Bill 36, the primary sponsor being Representative Jared Bauman, which would ban what are called sanctuary policies, require local and state agencies, including jails, to cooperate with federal immigration enforcement, and possibly involving the Attorney General in these operations as well. There's again all kinds of constitutional issues that were raised when the previous administration tried to expand them. It's the same concerns that everybody has now. The other sort of angle that folks have come to in terms of cooperation, or just sort of cracking down on the idea of a bunch of people here who are unlawfully present and are committing crimes and sort of all of that rhetoric, is a bill, House Bill 76, also sponsored by Representative TJ Roberts, that would condition pretrial release on proving citizenship or lawful presence. Now, pretrial release is something where somebody has been charged, but of course they have not been convicted. They have not gone through the process. So it's basically saying we're going to hold people without any real proof that they've even committed the crime, without a conviction, without a sentence or anything like that, until they can prove U.S. citizenship. Now, I'm a naturalized citizen. I was naturalized when I was 14 years old. A lot of people in my position have started carrying around passports. If they are citizens, they are carrying around green cards. It's something I advise as an attorney, and through our nonprofit, we do a lot of know your rights trainings and information sessions as well. Because this is not a constitutional bill. Our Constitution has due process provisions in it, and those provisions apply to everybody in the U.S. regardless of their immigration status. And so this is something where you're essentially just holding somebody without cause or justification until they can provide some paperwork to a jailer or somebody who may or may not even know what that document means or what to look for. And it's given a 48-hour window to do that. There's a couple of other bills. Representative John Hodgson, it's House Bill 70, essentially would make it a requirement for any state-issued ID to indicate on that ID whether that individual is a citizen or a non-citizen authorized to be in the U.S. Again, the sort of administrative workload on our clerks is unknown. There's not, as far as I know, a fiscal impact statement or anything like that. And in addition, it would require them to themselves, so the clerks, figure out what is this person's status. Again, there's a wide range of lawful statuses that a person can hold in the United States. So it would put the burden on individuals who are not immigration practitioners or experts in immigration law to figure out the status and then figure out how to indicate that on all state-issued IDs. And that is the window for implementing that is January 2027. Representative John Hodgson also has a bill that would make it a crime, a misdemeanor, for a person to be looking for work if they don't have work authorization. Again, unclear how any of this would be enforced, who would be enforcing it, how somebody would determine whether they are authorized for work or not. For instance, there are people who have asylum claims pending who do get work authorization. There are people who are here on parole who have a different document that might show work authorization, and that even changes depending on the country that you're from. So it is unclear who would enforce it or how that would be enforced. Certainly, our police are not trained to look for any of these documents. And of course, there were a pair of bills filed by Representative Shane Baker, and those were aimed at making sure that nobody who is a naturalized citizen can run for local or state office. So local office would be your, local council, your county commissioners, mayors, school boards. They would have to be born in the U.S. And cannot hold dual citizenship. And a quick note about dual citizenship, again, when you get naturalized, you have to swear an oath to renounce all allegiances and other citizenship status, regardless of the country. So the United States doesn't allow for dual citizenship on our part. Other countries, just for practical reasons, people might own property, they're paying taxes, they might have some family still in that country. So they allow for their citizens on their side, right? So let's say Germany allows for their citizens to maintain their citizenship regardless of the United States. So the dual citizenship part comes not from us; it comes from the other country where the individual might hold nationality or have been born. So that's 186. That would be specifically for local office. House Bill 259, also Shane Baker, would require a constitutional amendment to Kentucky's Constitution to impose that same requirement for all state level offices. So that includes legislators, that includes your attorney general, your secretary of state, anything like that. So offices on a statewide level. And a couple of other ones by Representative John Hodgson. Again, one is a constitutional amendment that proposes that people cannot hold office until 18 years after they've become a citizen, and that's kind of I guess, a way to get bypass the significant constitutional violations that Rep. Shane Baker's bill would have, violating directly the 14th Amendment, which specifically states naturalized citizens can hold office. It would have precluded a lot of our founding fathers from being able to hold offices or positions in government. So they specifically put naturalized citizens in there. Rep. Hodgson's bills, I think, are trying to bypass some of that by saying naturalized citizens can run for office, but they have to be they can only do that 18 years after they have become citizens. And of course, we know that people don't just become citizens when they turn 18. I'm not sure what that 18-year window where that came from, but especially for folks that are coming here as refugees, it takes a long time. So folks that come here as refugees have to be green card holders for 5 years, after which they can apply for citizenship. They might come here when they're 50 years old, 60 years old. So if they have any interest in holding elected office, they would be barred under this pair of bills until 18 years after they got their citizenship. There are some other bills that have been kind of proposed and discussed but have not been filed yet. I'll be sure to update on some of that. But these are the bills that have been filed. They've been assigned to committee. They have not been assigned to an agenda for any particular committee meeting at this time. And I'll pause there for questions or comments. I know that was a lot.
Any questions for the representative? Not hearing any. Thank you, Representative Kulkarni.
Of course, of course.
Let me say that as an individual, commiserate with what you and several others have to endure in Frankfurt during the legislative session. in terms of that. And wherever this body can be helpful, we want to be helpful. But as you also know, that we're also being put under the microscope to change some of our ability to do the work that we've been doing for the last, more than 50 years. So.
Yeah, and it's unfortunate. I want to thank you all for the work that you do. And I will share, I shared with Juan that presentation, and it's just data, and it's more, DEI, all of this sort of focus on removing equity from all aspects of our lives. I think it's important to look at the contributions that people make to our Commonwealth. And so that presentation was largely about the really significant economic contributions that are made by immigrant and refugees communities just to Kentucky. So not even nationwide, but just to Kentucky. And I think that's important. So I'm happy for Juan to share that out with all of you all, just for some context, right, in terms of the folks that we're demonizing and vilifying. But it's happening to everybody. And so I really do appreciate all the work that you all are doing. And I'm happy to have further conversations on how we can best support our Kentuckians.
Okay, well, we appreciate it. And Juan will distribute to the commissioners that presentation. I think that data would be very meaningful, valuable, and can be useful in terms of some of the discussions that we're engaged in. So again, thank you for the work that you're doing and continue.
Thank you.
Okay.
Thank you. Thank you all very much. Have a good rest of your day.
Thank you.
Okay.
Thank you.
We're gonna jump around in terms of the agenda, because we got some commissioners that have to depart early. We'll go to Colt, and we're gonna talk about, particular legislation pending that is directed at this body.
Good morning, everyone. I sent to you recently several what I call primers on some legislation that's pending. Most importantly, House Bill 468. I trust that everybody has seen that and reviewed that, and hopefully come prepared to give me some feedback on it. Cynthia and I met at the Capitol Annex with a representative of the sponsor of the bill, and gave him preliminary thoughts on what we thought about the bill and impacts it have on the commission, and we left that meeting with the directive to come back and speak with you all and ultimately convey the commission's thoughts on House Bill 468. I don't know the best order of how to do this, Chair Burris. I don't know if you want me just to go through the bill or if anybody wants to jump.
Once you go through the bill.
Okay.
And then commissioner can jump in where they have questions and all that. And then we need to be prepared as you go through it. I'm not certain what the nature of your and Cynthia's discussion was, but we need to know what that was. So commissioner can focus on what they need to do, knowing that whatever we have has to be there tomorrow. Is that right?
That's right. Yeah. Okay. Well, I can tell you what we thought too. And as we go through this, I'm going to read from the primer. So if you guys have that in front of you, that'd probably be helpful for the discussion. All right. So to begin, there are certain legislative purposes for House Bill 46. And let me back up. I think by and large, this bill is there's a lot of good and there's some things that are not so good. So among the things that are good, to resolve the Turner versus Norton problem, in that case, a few years ago, the Supreme Court, it was questioned whether or not the 2008 ADA amendments were incorporated into the Kentucky Civil Rights Act. In the Turner versus Norton case, the Supreme Court said, we don't know, that's for the legislature, basically kind of punted on the issue. This bill would bring in those amendments to the KCRA, which of course we think is the right thing to do. I think everybody would agree. It's a little bit more expansive with regard to coverage, which is of course the legislative policy in the first place for that bill. You'll see too, to resolve the Owen versus Kentucky problem, the election of remedies, we can get into that shortly. But by and large, I think this bill seeks to remove the adjudicative function of the commission as well as the local commissions, and to replace that with the Seventh Amendment right to a trial by jury. That seems to be the driving force behind this bill, as you'll see from the changes. So the bill itself amends 8 sections of the KCRA, repeals 5, and adds 1. Many of them are cleaning up just drafting problems that I think that are a product of this bill being an amalgamation of federal law just kind of packed into one state law. So some of the changes are minimal and just for clarity. But I'll hit the larger ones first. We're going to roll down to the end of page 1. The bill would amend KRS 344-190 by eliminating the commission's power to hold hearings on complaints of discrimination. As it stands right now, what we do, the statute in employment PA cases would allow us to charge cases and then move forward to administrative hearing. The housing cases is the same, but there's an election provision that says the parties can decide if they want the cases decided in court. From our meeting with the representative there in Frankfurt, they like that idea and they kind of want everything to look like that. The employment in PA, they want these things in court. And that's what the housing provision does. One of the suggestions that we had was maybe to condense the KCRA. Right now, there's a very stark contrast between the provisions that talk about the employment in PA versus housing. Right. And it seems again that they like the adjudication model that's provided for housing cases. One of our recommendations preliminarily anyway was to perhaps maybe make them all the same. And that can look a couple of different ways, but we can get into that too. Removing the power to hold administrative hearings is replaced by the power to seek relief in accordance with some of these changes. So House Bill 468 would allow for, after a probable cause finding, the commission to seek relief on behalf of the administrative complainant in circuit court instead of an administrative hearings process. To me, that looks an awful lot like what the EEOC does. EEOC doesn't hold administrative hearings. They file in district court, in federal district court when they find cause. I can give you my opinions on it when I'm finished going through the changes, but you'll see there under the top of page 2 now, it adds a specific power to exercise powers conferred in 600 to 680, which are the housing provisions. Seems duplicative. Of course, we have the power to do that. It's already in there. But again, I think what that's doing is just showing their intent to make things more like housing. Moving down to section 200, it makes clear that aggrieved private parties can file in court before they come to us. That's not new, but it would create an express provision in the law that would provide. But what it does do, going back to the Owen versus UK thing, is it would allow for parties to file both with us and in court. I don't know how much of an impact that's going to have on us. I don't know how many more complainants we'll have. I think complainants come to us with lawyers or they come to them without them. The ones that come with lawyers already know this and they're already going to file in state court anyway because there's no need to exhaust administrative remedies here. But I think it creates a little bit of a procedural problem when they file in both places. Because if we look down a little bit more on that second page, we can file a court action on behalf of a private party who's not previously filed a civil cause of action for the same grievance. So the way I see it is this: we find cause, and then if the plaintiff hasn't filed in court, we can sue on their behalf. If they have, we have to request that they let us intervene and they have to consent in writing. On the other side of that would be if we file first, they can intervene as a matter of right. I'm not really telling you anything that's not on the primer, and I'm going really fast because I'm trying to, in the interest of time. So if I'm going too fast, please let me know. It eliminates the ability to seek fees and costs. I don't understand the policy behind that. I think we should be treated as any other private litigant if we.
It's the gut, the ability of this body. So we can't cut your funding here, we'll cut it somewhere else, or you can't get the remedies for it. So we starve you.
Yeah, well, I get it. I don't think that would starve us, though. It's not like we're asking for fees and costs.
But that I'm thinking the thinking is.
Perhaps you're right. We brought that up with them when we met, and they were kind of responsive to the idea that they could think about changing that. I think we should be entitled to fees and costs just as any
Yeah,
plaintiff's
any other-
lawyer.
Right, yeah.
So I think that they get that. But the bulk of that is that we just sue in court. That's one of the main changes. What's the commission's thought on that? I can tell you what Colt's thought on that is, and Colt doesn't mind it. I think when we have the housing provides the election for the parties. If they want to go to court, they can. Every single time they do, with rare exception. And we go to court and we do that. And I think a lot of that is driven by familiarity of the parties with the courts as opposed to the administrative hearings. And if it were me, I could understand wanting to take it out of here too and go put it before a jury because they filed the complaint with us, they investigated here, and then we have a 13B hearing here. I would take it outside as well if I'm being candid. But we do have administrative agencies have been conducting administrative hearings for a long time. There are sufficient safeguards to the problem that I just described. The ability to go to court after the fact is there to seek judicial review of a final order. But by and large, I don't know how much of an impact.
I guess, there are administrative hearings, administrative judges regularly.
That's right.
That is taking place across many of the state agencies already.
And federal.
And to the extent that they're saying, okay, we don't want that here, are they willing to say that we don't need administrative judges in everything? How far are they willing to push it?
I don't know that, but it seems like I think the same school of thought would apply across the board. Sure.
Yeah.
I mean, if you want, the issue was, I think, and it gets more into the local commissions more than anything, I think, and their ability to hold these hearings,
Right.
because those are, of course, unelected folks, adjudicating, making findings of
How
fact.
many of those have occurred with the local commission?
Well, and that was our point. Now, I don't have the data before me, but we only know of two that are really going out and enforcing their local ordinances, that being Lexington and Louisville, because they've got the resources,
Right.
And the ordinances are robust enough to provide for that.
Yeah.
Many of these other places either don't have the robust ordinances to do anything enforcement wise, or don't have the money to do it anyway. So we explained that to him. We thought that the risk there, the fear that is behind this legislation isn't really a reasonable one. But I think the fear is the idea that we have rogue local commissions making adjudications under the law, and that should be better done by the Court of Justice.
Okay.
Yep. So that's the bulk of the issue here with this legislation, is what the commission feels about that. And then the second I described to Cynthia, I think there's two very big issues here with this legislation and several minor issues that kind of flow from it. First being whether or not we have administrative hearings that we just discussed, and the second, the amendment to KRS 344-320 would limit the local commission's ability to do anything but investigate. Right now, it says that they can receive, initiate, hear, and determine. The amendment would leave only investigating. And then they removed a bunch of other powers consistent with that change. Of course, there's no need to be able to compel witnesses or enforce orders if you don't have administrative hearings. So the long and short of the change on that would be the local commissions would only be able to investigate. And what does that mean? What does that look like? I don't know. What they investigate for what?
And the question is, how many of them really ever do it?
Yeah.
Just the two.
Yes.
Right. So even if it's just those two or all of them, and leaving them with only the ability to investigate, I mean, what happens after they investigate? The law doesn't contemplate what happens next. It just leaves them with the ability to investigate it. Then what? I don't know. So that's something I think we should, I think you would support me asking questions about that. And then you'll see on the end of page 3, there's a bunch of sections that are repealed from the KCRA. They pretty much just revolve around the administrative hearings issue. You'll notice there under 210, I say that it eliminates the answer requirement. As far as I know, the requirement to answer complaints in 210 is the only provision that exists that requires an answer at all. So to eliminate that may very well leave us without any obligation to answer KCHR complaints. I don't think that's intended, but I think it's an unintended consequence if it's left like this. And you can see the rest of them more deal with the administrative hearings. I think that the damages provisions under 230, that's what I cite routinely as support for a finding that the KCRA would award damages for unlawful conduct under this under the act. So if you eliminate that, where does that leave us? I think above the changes say you can request appropriate relief, whatever that is. The courts are obviously well versed in awarding relief, so I don't worry about that as much. It would eliminate 270, would repeal 270, which says you can't have them in both administrative agency and court at the same time. Again, it would allow for someone to walk in with a complaint. If they were terminated in their eyes unlawfully yesterday, today they could come file a KCHR complaint and say a Jefferson Circuit Court complaint at the same time. I don't know what the impact on us would be until probable cause, but I can see the respondents would be fighting effectively two battles on two different fronts, or one battle on two fronts. I can't imagine that's an intended consequence. They'd have to both respond to our request to investigate as well as discovery requests in the civil action. I just want to give you an overview of the changes. I can give you my thoughts on that. But ultimately, I would like some feedback on the admin hearings issue as well as the local commissions issue, as I find those to be the two biggest problems with the bill.
In your meeting with them, did they say what they saw, what was broken?
Well, what I got from it mainly is the discussion on the local commissions and the administrative levels. As Colt just said, the thought that someone from whatever county could have individuals hearing a employment case and making a decision on a employment case. Is the complainant getting their rights? Are their rights being exhausted? If they're getting a fair hearing, if these individuals from whatever county are actually hearing the case, are they truly getting their rights? I got the impression in the meeting that the whole idea of changing all these statutes is to ensure that the people of Kentucky are getting their full rights. And when it comes to filing a discrimination complaint, including the hearing.
I think it's more protected respondents' rights in getting a fair
Well, that's
hearing
what that's
way.
what
Yeah.
we see, but that's
That's
what I heard is that they were trying to protect the citizens of.
It's just where is the adjudicative power properly vested, I think is the question. They deem it not to be in the administrative agency or an AOJ or hearing officer, but more the court of justice. Like you said, though, administrative agencies that have existed and do exist, both state and federally, and they're sufficient, in my view, constitutional procedural safeguards that provide for these things that is well settled. Admin hearings is not new by any stretch,
Right.
but they would seek to eliminate that ability here and properly put it in their eyes, the court of justice.
I just have a curiosity question. Is the state gonna give the courts more money to manage this? I'm just, again, because if you're low income, you may not have the necessary resources to fight in the courts. It may be to your advantage to fight at this level.
Right, yeah.
And that's what I'm trying to say.
Well, I think that is the point of, like, if you look back in history about when administrative agencies and adjudications came to be, I think part of the argument for them was judicial economy, right? We want to keep things out of courts that don't need to be in courts.
Right.
And also, to your point, part of the appeal to this would be that it reduces or eliminates the barriers to being able to pursue your rights.
Right.
By being able to go here. Now, they would still be able to do that. We would basically provide them with the free counsel
Maybe,
after cause. Yes.
maybe.
Well,
I
take
think
the typical complaint who has an issue. Most of them, one, don't know the procedure, don't know the process, and don't have the resources to in fact battle.
We agree.
And one of the things this agency does is help to make the playing field level,
Right.
okay?
Mhm.
And as they think that we've been unfair to respondents, all you got to look at is how many no probable cause cases do we approve?
Sure.
Okay?
Sure.
Yeah. So
And
it's
they-
really, I see an attack on people with fewer resources as a way, and for a way of them to protect them. That's my opinion.
And in the
What-
rural
what-
areas, that's
what-
a problem.
Oh.
Because they don't have enough resources.
Yeah, speak up, commissioners.
Yeah, I mean, this is very important, especially with respect to the local commissions. I mean, it would really change a lot about what we do here in the state commission, but it'd have a real impact on the local commissions for sure.
I think I agree with where you come down, Dr. Burris, because the reality of persons of meager income, they're gonna feel the greatest effect from this.
Right.
They don't have the resources, where there's not a human rights commission with the authority
Right.
to act on their behalf in this fashion, they're left out.
Right.
And it's just gonna go downhill from there.
You know, the cleanup that they've done, those provisions, I think, to me, from my perspective, are good and something that needs to be done and probably long overdue.
I agree.
But to then take the next step in terms of what, where local hearings can or cannot be held, I think is an affront to the rights of a ordinary citizen with few resources. So that's number one.
To play devil's advocate, I just anticipate a response to that. I mean, arguably, under House Bill 468, if it were to pass, the person would file a complaint, have it investigated, we find cause as we do, then we file a lawsuit on their behalf. So what changes?
What changes is the ability for that case to immediately go to court, where are we gonna be there as on behalf of that complaint?
It removes our ability to hold administrative hearings, but it does provide that we, and I'll use their language, not my own, it adds the power to seek relief on behalf of an administrative complainant. And it says we can file a court action on behalf of a private party who's not previously filed a civil cause of action on the same grievance. So,
But then it goes one step further is that they have, that complainant has the ability to file a complaint in court.
Mhm.
Our ability, if we find something additionally wrong with that, our ability to intervene is dependent on the complainant consenting to us being involved.
that part I take issue with.
And I think as a body, have, at least we, part of the reason we exist is our ability to, in fact, we may see something more in the case than the complainant may see alone. And the ability for us not to get that corrected, and that may, yeah, you know, it may be an issue that for a single complainant it is, but we may see a bigger issue in the broader arena that we need to address.
But it gives them that ability to
I know.
take it or leave it.
I
No, I mean, it respects the right of the complainant, I think.
Right. And the other thing, it also changes the statute of limitation by shortening that, basically no tolling.
Right, and I think they would say that is not a problem because it allows them to file in both places. So whereas previously they could file with us, we take X amount of time, and then that time doesn't count toward the state. I know you
But
know.
again, if the complainant gotta have the resources to be able to file.
Sure.
Yeah.
That's right. So if the hypothetical person that does not,
Yeah, right.
they file with us.
Yeah.
And then we cause it or don't.
Mhm.
Where does that leave them?
But it also says that if they file with us, our investigation doesn't toll the statute of limitations, because they still gotta go to court before, even if our investigation is longer.
we've got three, well, that's the problem, right? But that would encourage prompt action by us. That's the argument they say.
It would cause prompt action by us if we got the resources to be able to do that and address it. Part of the problem that we struggle with now is what, 19 or 21 of you, how many?
18.
18, excuse me, 18 of you,
Yeah,
when it used to be almost 40.
sure. And the cases are going up and
Yeah.
and the funding's going down. I mean, we, that's certainly something I think we should mention.
So have you written all this up? So that we can sign off, so they have the commissioner's signature on it tomorrow?
we could pass it around tomorrow morning if everybody would be on board with that.
Because we only.
It was challenging for me to anticipate what you guys would think about this. So I didn't draft.
No, my note to Cynthia was for you all to draft something that we could.
I got it. No, I got it.
Review, and that we could sign off, because my expectation, we would talk about it now. And to the extent that we're commissioners here, all the commissioners present would sign it.
Well, I can tell you a couple thoughts I had about that. Would you want only 4 to sign it?
Would I want what?
Only 4 to sign it?
No, I was expecting more to be in the room.
I was not.
And now in that case, I think it falls to me to sign it as a chair.
I agree with that totally. And I was,
Yeah.
hopefully you
Yeah.
give me about at least 24 hours to get that done.
Okay.
But I still don't know what the consensus opinion is on that.
Well, let's go, we can go around the room.
I'm okay with the chair signing it.
Well, he looking for on the substantive content of what he's discussed, where you are and what your thoughts are.
My thoughts has to do with low income people in the state. The bottom 6 or 7 states all have low income. And the people who are low income will be financially challenged to go to the courts or hire a lawyer. Their advantage is to have the commission.
Well, that exists now, and the commission would still exist going forward to do that. It allows us to seek appropriate relief on their behalf. So it's still kind of the same thing for us. I mean, it just changes our venue. I mean, I think our day-to-day, Bill, I mean, you can tell me what you think too. Our day-to-day, I think, remains the same. With a couple of exceptions. We cause a case, and then instead of requesting the appointment, the
exceptions are what?
I shouldn't assume that you all know the process. When I cause a case that's employment or PA, public accommodations, after a brief discussion with counsel on the other side, I then at some point in time request that the Attorney General provide us with a hearing officer. That hearing officer works for us effectively, and it would preside over the hearing and ultimately issue a recommended order for you as the body, the commissions to approve, reject, modify, what have you. So with the changes, if they were to go into effect, what would happen is then we would cause a case. Instead of requesting the appointment of a hearing officer, I would just file an action in court on their behalf, as we do in the housing cases. In the housing cases, we cause it, someone says, hey, I want to go to court. We have X amount of time to file a complaint in court. And the complaint is the KCHR versus the respondent. Okay. I assume that's how it would go in employment PA cases under this change. I would file in whatever circuit court under KCHR on behalf of Jim Glenn, and we'd go forward as we would. It's a change of venue, more or less. It's a form change altogether, but yours. I think we can still, we can still advocate and achieve relief for these people who have been wronged under the statute. I think that is still there. It's just a different forum. Personally, if you want to ask me, I think lawyers would rather be in court. Do you agree with that?
That's for you litigators.
Well, sure.
I'm a transactional.
Understood. Well, I told you that when these housing cases get caused, the only cases that have been caused in housing that have not proceeded to court are those without lawyers, right? Lawyers every time. And I've got to talk to several, of course, over the course of these things, and it's because they're familiar with the process. And I think the process would be effective to still achieve results with these people. And in a lot of ways, I think it could be better. In a lot of ways, it could be worse. I think the hearing officer's ceiling on how excited they'll get on a case isn't that high. I think a juror's ceiling is higher, which will provide better relief for the complainant. I tend to think the floor is lower with the jury as well. So it goes both ways. I don't know. I will. It's not about what I think.
Others, Commissioner Holloway?
Colt, this is for you. If the term seek relief, does that mean after the fact, or would that allow someone of minimal resources to be involved in this process without having to put out money?
Yeah, well, I think their financial obligation remains the same. I mean, we seek relief for them now. We seek relief for them in the administrative hearings process, or in court in the House in case it gets elected. So it really just comes down to what happens after we find cause.
And you said above cost. So the person is still going to have to pay court costs, correct?
No.
Okay, thank you.
But the bill would prevent us from recovering our costs and fees expended in the course of the litigation, which I think provides an unlevel playing field, which is an issue that I think we should address with them. I think we should still, as any plaintiff's lawyer would, be able to recover their own fees and costs if they're successful. I think we should be as well. I don't understand.
So put that in there.
I will. That's, yeah.
Just a quick question. Does that mean the state's gonna try to cut our budget in the process of this bill?
They've already done that. In the proposed House Bill 500, I think it would have. Brandon was going to get into that, but
Yeah, we're gonna talk about that.
I don't think it's you know, hand in glove here. I don't think that one is with the other. I don't know. It's hard for me to suggest.
Games.
It sounds like, I'm kind of a bottom line here. It sounds like there's a move afoot to centralize, again, power and authority in Frankfurt. In the process, undercut the work, whether it's through direct language like this or removing funding. Either way, it hinders the commission's ability to do that which has normally been done. Claiming to have safeguards for those who are most vulnerable,
Right.
and might for some, but others it does not. And so, I don't know what stops this animal from moving, but it's part of a much larger agenda than what we're talking about today. We know that. And so, how do we put that in writing? I don't know, I guess that's where you guys have to work that language out.
Commissioner Worth? You still
His
muted.
voice is.
There you go.
Right.
Thanks, Chair. I did receive all of the materials and I read them, and I will certainly defer to having you to sign the document that we're discussing. When I was reading through the documents, I was struggling with this basic question: what problem are we trying to solve here? That's the number one thing that kept coming back to me. And maybe this is my learned pessimism in life, but it did not appear to me that this is first and foremost about the establishment of greater efficiencies or effectiveness. It seemed to me that this could be dealing with the exact issues that you've already heard from the other commissioners, that there could be a very basic human tendency here to power grab. And that's my concern. And so I am a student here listening to this discussion today, and I'm certainly going to follow the lead of your recommendation and that of Colt. But I still am struggling with the basic question of what does this solve? What is the problem that emerged that created this initiative? That's my comments, but I'm certainly, like I say, I am no expert in this field, and I'm learning a lot from the documents shared by the team and from the discussion today. And I have zero problems with you signing the document that capsulizes our response.
I think the problem is only one that is hypothetical, and that's the rogue local commission or rogue hearing officer making adjudications that have the force and effect of law where this sponsor of this bill thinks that that power is more appropriately vested in the courts.
But did they point to
Well,
any examples of where there's rogues have gone off the rails?
not really, and I think we pressed them on that. I think we
They
asked.
did, and I don't think they truly understood our local commissions in
I
the state.
think that's true
And
too.
the fact that we only had two that were very similar to us, which was Louisville and Lexington. And we explained, we also provided them a list of all of our local commissions.
I think that's true. I don't think they I hate to say that, but I don't think there's a real clear understanding on what these local commissions do and have the power to do.
Not surprising.
Well, perhaps it's not. And whether we've heard it called a power grab a couple of times. Who's grabbing power from whom? I think it would just change the forum of where these things are decided. So,
Well, I think it's more informed. I think it's putting the putting more weight on the side of the respondent than it is the complainant.
and how?
Because if you have a complainant out there who wants to file, and they say, oh, go file the court. The barriers to getting into court, if you have no resources, are greater. Granted, you can file both places.
That's right. Or file here only.
No, or here only. But I think it sends the wrong message of what we're trying to do and the rights that we're trying to protect, at least from my perspective in there. As again, I get the cleanup on the ADA stuff is good,
Yeah.
is well long overdue.
Sure.
No, I guess maybe I was reading one of the other bills that added some more protected classes.
Yeah, this one did not do that.
Yeah,
There were a couple.
another one pending. I think it may have been in Europe.
Yeah, Senator Neal,
As his bill.
yeah.
Oh, well, okay. It ain't going anywhere.
Said it's been filed every year that I've been here, so,
Okay.
but
But I think the cleanup on the ADA is really good and
Okay.
they can be complimented and commended for doing that.
Yeah.
But at the same time, while you're cleaning that up and making it more explicit, there are potential limitations in terms of eliminating or restricting or eliminating what I guess the individual complainants may see in terms of the process. And then I guess you start with the original, what are we trying to solve?
yeah. No, I understand.
Yes, one.
I just want to advocate a little bit for the local human rights commissions. So I have been working with the local human rights commissions for over 20 years. And one thing that I have observed that they have struggled to recruit new board members. Partly is because the misperception that the commission cannot do anything or cannot do much, it doesn't have much that enforcement power. So by removing or changing their power or taking away their power, I think that will have a devastating effect to local human rights commission. So you as a body of the board of commissioners, I really advocate that. Just leave as is.
And I think to more in the same line of what you're saying, I think what happens as there's other groups up there that are going to be fighting the local commission battle other than us. And largely has to do with those fairness ordinances that are enacted all over the place and other ordinances that are passed by people in the locale because that's what they want and that's how the process works, right? So by removing the ability for these local commissions to go out and enforce these local ordinances, those local ordinances, they're effectively null and void, right?
Yeah.
Which might
Be
all right,
be
so-
objective.
so that's of course a problem. I've had some discussions with some folks who are up there trying to advocate for them on the fairness side of things too. So certainly we should speak our piece on it as well, but just to supplement what one had to say.
Do you have enough to put together? Or do you need more?
Well, no, I don't know what the position is.
He doesn't want to speak. Board.
I'm afraid that
I've said what, well, look, as we went around the room, it seems to be, at least my observation is that in, one, that as it relates to the changes, threshold question is, what are we trying to solve? We don't see the problem or understand the problem. That's one. Number two is, I think we like the ADA changes in terms of that incorporation. We're concerned about eliminating the ability of local commissions to do investigation. We see that as taking away a number of, taking away the voice of local communities. Four is, as it relates to this commission, taking away our ability to hold hearings. We see that as again, a further erosion of the rights of individual complainants and our ability to do that. Fifth is the ability to recover court fees and costs. What am I missing, folks?
I think we carried it all.
I support your synopsis, Doctor.
What kind of
Bill, he can speak.
No.
Huh? Bill, he can speak.
Bill, you can speak to the group.
Oh. Cole told me I could too, but he said, but. Well, from my experience, overall experience, I've been through a lot of the processes that involve administrative adjudication of issues versus the court's administrative duty, responsibility to do that. And there's always been a huge struggle. And the struggle that really takes place all goes back to the right to a jury trial. At the end of the day, that's the only thing that an administrative body cannot conduct is a jury trial. Right? And you got a statutory constitutional right to a jury trial. And so that's where that struggle has taken place over years and years and years. And it's gone back and forth. There are some people that would take the position that the administrative decision or the administrative body is responsible only for making a recommended decision or a recommended. I used to do this all the time as a domestic relations commissioner. We held hearings and we did all this kind of stuff. At the end of the day, what we did was we wrote up a report of what our findings were and made a recommendation to the judge as to what the decision ought to be. Now, 90% of the time, the judge, rubber stamped it or whatever, but sometimes. But the idea is that you always had this body, you always had the court involved some way. The court that had the power to do something involved some way. So, and the other thought that I had, or that, when I've been involved in these things for a year and a half, okay? But the first thing that occurred to me when I came over here was the responsibilities that this Kentucky Commission on Human Rights has. And it's not solely to represent people, the interest of people that have problems or have been discriminated against. Our responsibility is to eradicate discrimination. I think that's what the statute says. And we go about doing that by several ways. We can conduct training, we can go out in the community and advise them of all, their responsibilities to employers and all this. Another way that we can do that is by representing the interest of an individual that has had been discriminated against. It may not, we're on behalf of, that individual is not a party to the process until maybe later they're joined in the process as an individual. Or I guess if they go to court, then they become the driving force. So again, all I wanted to make sure of is in this process, we have a responsibility to eliminate discrimination in the state of Kentucky. And by allowing individuals to go directly to the judiciary to solve their case or whatever, are we abrogating our responsibility?
Circumvents the ability of this organization to fulfill its statutory obligation. Get that one? Put that one in there.
Was that a but? You didn't get it?
Yeah, I hate to advocate, for the bill. I don't think this would abrogate our responsibility to do that.
Well, we take the same approach they do. Our threshold question is, what are you trying to solve for? And so we assert that part of it is to abrogate part of our responsibility. They have to come back and say, we don't believe that, Mr. Litigator.
And Code, I think Bill made a mention of, because they did talk about a jury, rather 3 people from whatever county.
I was gonna,
Yeah, that was one of the things that was brought up in our,
yeah,
they have a jury trial rather than
yeah.
whoever from whatever county. 3 people that,
Yeah.
How does this affect the time frame that's being pressed in here? Because my belief is that you don't just file and you're in court next week.
Yeah, no, that certainly wouldn't happen. It wouldn't impact. I think it's part of the idea is that it wouldn't take as long for some of these folks to receive relief on either side. I don't think it's a secret that sometimes we can take a little time, and that's a lot of it to do with that. I think with more staff, that's of course something that we would overcome. But I do believe that is part of the sponsor's issue with our office, is that it might take too long to get relief.
But I was asking from the court side, from the other side.
Oh, yeah. Are you asking me which is faster? Do you think, is that like, if they have the ability to go into court, are they able to receive relief quicker than
Right.
here? Well, necessarily, I think the answer would be yes, because because here's what happens. We start, I really hate to advocate for this bill, but we start and we investigate and we go through our process and then we file in court versus filing in court. So I think there is inherently some additional time required. Not much.
That's because we do a thorough investigation.
I think that's
where the
true.
court gets this said, here's my view, now you choose.
More or
Okay.
less, yeah.
And I think the nature of our investigation is to be fair to both sides.
Sure.
To find out what the facts are.
Yeah,
And I can tell you that in some court procedures, that is not always the case.
sure.
I agree with that.
Yeah, no, I think so too.
Okay, we need to bring this to a conclusion because we got 2 or 3 more major items on the
Yeah.
agenda today.
All right, I'll prepare something. I'll submit it to you.
Well, I want you to send it to all of the commissioners.
All right.
And if they got some additional input, they can send that to us. We try to get this out of here, say by noon tomorrow, or at least finalized, so it's ready to go by the end of the day.
That's right. It's got to be by the end of the day. And I'll work as quickly as possible on that. I also want to make one more mention that this would amend our timeline to determine probable cause. Did you notice that in there? It would extend it to a degree, but only by a few days. It would still leave it at 30 days. I can tell you my fear on that. The statute is the same. We have 30 days to determine probable cause in employment PA cases. This wouldn't change that. but it would alter the language a little bit. And if you think about what courts do with respect to statutory construction, if they change the words, they probably want to change the meaning.
Yeah.
There's been some safeguards that would allow for us to exceptions to that 30 days. Taking time longer. There's a case from 1972 that would support our idea that 30 days isn't some sort of statute of limitations. Okay, but with this change, I think it perhaps might render that inapplicable. What does the commission think about the housing statute allows for 100 days to determine probable cause, and it also allows for exceptions, and practicability is what the exceptions.
So what does staff want?
Well, the staff would like more time.
Like the 100, well, then,
Okay.
yeah, okay.
And then also,
Everybody agree with that?
Yeah.
Okay.
I think too, what do you think about consolidating the Kentucky Civil Rights Act, Employment PA, and housing to all play by the same rules?
Would be nice.
I think it'd be nice, and I think that they were receptive to that. I think that if that's something that that we want to do, if we did that, I think it would be appropriate then to ask for that 100 days to kind of apply to all. If you guys
Then
support
ask for
that.
100 days to apply to all of them.
Yeah.
That's what we'll
Okay,
do.
yeah.
Oh, the other thing I would like to add, if I can,
Please.
when you send a note out in the first sentence, asking to respond by 1 o'clock Eastern time, which is 12 o'clock Western Kentucky time, is a response, because we have a timeline that splits the state. Just a heads up.
Yeah.
Sure. That's noted. Okay. Anything else on House Bill 468? I think we've reached a consensus, and I'll draft that consensus.
Anything you want to add on the other bills that you sent?
No, the other bills, these are all existing, I think, in various stages of the legislative process. I think many of them, including House Bill 468, have not advanced out of committee. I think Senate Bill 72 has. Senate Bill 72 is our Healthcare Heroes Recruitment and Retention Act. This is something that's been filed many years over. It would create the exception, it would prohibit discrimination against healthcare providers when they refuse to take certain action in their medical practice.
Yeah, it passed out of the Senate the other day.
Okay.
It came out.
Okay. There's a lot of debate on this one. I don't really know what you would like me to do on it. I can explain it further if that's what you're asking.
But I'm interested and want to know more about it. Just know that the medical associations are opposed to it because they think it's in conflict with the Hippocratic Oath. So, but Senator Thomas from your hometown said it is legalized discrimination.
So, yeah, I mean, I think it's overbroad. I think it's a little vague. I think it poses a lot of problems. I think it would allow people in rural areas with limited access to healthcare, if a particular doctor does not want to treat the person based on, I mean, it's so broad, conscience, moral, ethical. That person can be refused to be treated and then be without anywhere else to go. Which could be life or death in a lot of ways. That's my take.
Yeah, but I say it passed out of the Senate on partisan lines.
So
Going from cakes to doctors.
for our purposes, that would create a couple sections of the KCRA, which would prohibit discrimination against that doctor who refuses to do that. And okay. Any other of those the other ones are the same ones we've seen several times. The Crown Act is back. The Ban the Box Act is back. Let me see what else we've got. Senate Bill 108. Senate Bill 108 is back. This is one that would it relates to employer mandated vaccinations. it would create the exception for employer mandated immunization requirements for sincerely held religious beliefs or whether if it was injurious to your health. So that is something we've seen before. I believe it's still sitting in the committee. Senate Bill 115. Senate Bill 115 is the one from Senator Neal, which would add sexual orientation, gender identity to protected class list for all case types.
Any other questions for Colt on pending legislation or anything? Okay, thank you for that, Colt.
Sure. Sorry, I was again trying to be fast. I hope it didn't
No, we need to be
confuse the
fair.
message.
So don't, yeah. You take care of that. We go back to the agenda and we need the consideration approval of the minutes of the January 15, 2026 meeting. Is there a motion for approval of those minutes?
Motion to approve the minutes.
Second.
Can move second that those minutes be approved. All those in favor say aye, raise your hand.
Aye.
Opposed, abstentions, those minutes are approved. We go now to sections report, and first up is the executive director, Cynthia.
Good morning. Just wanted to let you know that we are still waiting to hear get some information from HUD. The last time we checked, we still have not heard anything as far as we've met our contract, but it's getting paid for our contract. We haven't received any information on that at all as of yet. With EEOC, we're continuing to work with EEOC, and he's working with us to make sure that we're meeting our contract and submitting the cases the way that they need to have them submitted. Personnel, just briefly, I'll tell you that we do have a vacancy in the agency. We are holding off on filling that vacancy until we get a little bit more information about the budget. We recently, since this has been written, we kind of know what may happen, but we're trying to determine where the need will be still. And that may be affected not only by what we receive in the budget, but also depending on what bills get passed through the budget of where our need may be for to fill a position. There's 37 cases that were submitted to me for review and approval since the last commission meeting. 15 were employment, 16 were housing, and 6 were public accommodations. Of the employment cases, 10 were no probable cause, which kind of goes to what we said before about the percentage of NPCs. 1 was withdrawn with settlement, 2 were withdrawn without settlement, and 2 were administrative closure. Of the 16 housing cases, 14 were no probable cause, 1 was a conciliation, and 1 was an administrative closure. And then of the 6 public accommodation cases, 4 were no probable cause, 1 was withdrawn, and 1 was withdrawn without settlement. With settlement, and 1 was withdrawn without settlement. I also wanted to mention to you all, because I believe at the last commission meeting and this commission meeting, you may have seen more administrative closures. I just wanted to kind of go over some of the ones this time. 1, the individual is deceased. We found that the individual was deceased and there was 1 where we were unable to locate the individuals. And so.
What question, since it's not necessarily on the cases, but in your meetings with the staff person, did they did y'all share with them that the majority of the cases we see are associated with disability and not with race?
Yes, we did. And not only that, we provided information toward the middle of last year. They received a list of all of our cases, which ones were filed, how they closed, when they closed, everything. All that information was provided.
Get any reaction or just they let it roll on?
They let it roll on.
Yeah.
We did,
Very aware that there was disability. We always kind of lead with that.
we reminded them, and we
Yeah.
ended with it too, if I recall. We
Yes.
ended with the idea that everybody in Kentucky belongs to a protected class. These things impact everybody that lives here, all constituents of all legislators. Something to keep in mind. We wanted to keep that in their forefront.
Curiosity question, 85% of the population in the state is of one group. What were the disabilities larger in that group? That, I'm not sure. Minorities only make up like 15%, 12 or 15% of the state of Kentucky. Was the people with disabilities
Are you asking? for
connected with the
With
15% or the 85?
Yeah, I don't know if we compiled that data.
Yeah, we have.
I just anybody who read through it just made it just a general observation.
I've seen disabilities come in all shapes and sizes, that's for sure.
Okay, I just said a curiosity question. I'm sorry.
That's an interesting question, though.
Yeah, it's almost like the Chinese were put in in camps during World War II, and we just don't identify it as that. We don't identify it like Hitler. And I'm sorry, too much side information. Apologize.
But we're continuing to work with other groups just to have alliances. Along with Louisville and Lexington, we have a meetup that's coming up in Lexington. We're doing virtual meetings with the Cross-State Agency Working Group. And so we're continuing to try to get information and share information, trying to get best practices. Most of it, as you may know, right now is dealing with the ICE issues and the immigrant and refugee issues. But they've also shared some other things with us about how they are educating the public about their agencies and what they do. And one of the things that we're hearing is that they're going back to the history of why we need these agencies, why the agencies are here, why they're still needed, and the pluses and the gains that have occurred over the years. The states are saying that it's a good reminder to tell people why we need to be here. So we are working on that as well.
I hate to jump back, but on the cases, when
Yes.
the cases, 10073 E/R, does R mean reconsideration?
Reconsideration.
Okay.
Yes, sir. And we'll talk a little bit more about it, but we're also coming into the season of the Kentucky Civil Rights Hall of Fame. And as we're talking about local commissions, one of the things that he and his staff have been talking about is encouraging local commissions to be more involved in this process so that we have a full representation of all the people that are doing good work throughout the state. I think most of us agree who have been here for a while that the well-known people who have done the work are already in the Hall of Fame. But there's a whole lot of people that we don't hear about or know about that we want to make sure that they get recognized as.
So there, any questions for Cynthia? Okay, go to budget and personnel, Brandon.
Good morning, and good morning to you all online. You have my report before you. I will talk about the budget bills pretty quick. On February the 3rd, House Bill 500 was sent to the Appropriations and Revenue Committee. Today is the first day of the second half of the session. Today's the 31st day of this legislative session. There's been very little movement on the budget bills. The Senate's still waiting. So
At the end.
yeah, you've got the numbers in front of you. At first, if you'll notice, there was a decrease in fiscal year 28. I didn't know. I can't see under the hood of how they calculated their numbers, but after looking at it, I believe that is probably due to the 5% cap on increases for employee health insurance. I don't know. There's been a lot of talk about that online, and amongst state employees from. So. I'm assuming that's where that's the decrease in fiscal year 28.
I was gonna ask you that.
Yeah, that's my guess. I haven't asked them for clarification, but,
And they actually did 15,000 more than the governor's budget in the first year of the biennium.
they did.
I'm
Not
trying to
sure,
understand that too.
I don't understand that. I don't know where that 15,000 came from. We, of course, did submit a 2% and a 3% budget reduction plan that continues on into fiscal year 27. If I had to guess, I would say that the governor's proposal included that 3%.
Okay.
And maybe this, the House Bill 500 just went off of our baseline budget request.
On the FY 26 enacted operating budget.
Yeah.
Had those numbers been reduced by the 3%?
No, they haven't. You know, they haven't done anything with that yet in the system. I'm a little curious about that myself. I probably need to check on that. I mean, we are planning for the last I heard that we submitted it in draft proposal. The governor did hold a press conference and announced the 3% budget reduction was in effect. We have not heard from our liaison, but that is something that I probably need to check on. But we're planning for reducing those numbers. I just haven't reduced the official numbers.
And the next question, I think you probably have already answered this before. When HUD decided that we could no longer use HUD on our publications and printing, we spent, I guess this fiscal year so far, spent almost $30,000. None of that we can recover from the HUD agency funds over there.
Yeah, I mean, I can move it to the HUD agency funds. We'll see how at the end of the year, that'll definitely be a candidate for moving to federal funds when I'm adjusting things to spend it properly.
Well, then I guess it's maybe a question of timing. You may not, as I think about it now, haven't answered the question, may not want to do it until after April 15th.
Yeah. So we'll see.
Okay.
And yeah.
If I may, a question relates back to what we were talking about. It may be a good opportunity to be, we mentioned the dollars. It's probably a good time to make a request for that. And also, is it beneficial, do you think, is there any need to request an increase in the federal spending authority, or is that something that is more likely to occur than just a increase?
No, you mean in this fiscal year or for the budget?
For the budget.
I'm not super concerned with increasing it in the budget because they generally approve increases in federal funding if you've got the cash.
Okay.
So
I forget I mentioned anything. I was
You got the authority to spend it.
yeah, well,
Right.
and so it would be an increase in the authority, that I think that's something we can get approved in the year that we need it.
Yeah.
Okay.
And for this year, we're kind of right on target. I mean, of course, it depends on what we do with the open position and the budget reduction, but.
Any additional questions for Brandon on budget and personnel? And like Cynthia said, we'll want to figure out how the vacant position, how they gets allocated.
Yes.
So.
Are we able to keep the money?
Wrestle over.
Cedric can go.
to the death.
Are we able to keep the state money, when the position is open, do we have to send it back to the state? Or are we allowed to spend it during that year without sending it back?
It's a line item.
During the year, yes. At the end of the fiscal year, the general fund, the state general funds, yeah, they're taking those. So.
Okay.
I try to use them.
Any other questions for Brandon? The Cedric disappeared, so
Yeah,
you're gonna do the enforcement?
Yeah, he had an emergency, so I will do the enforcement branch report. Basically, I'm not gonna read it to you, but if you have any questions on it. If I can't answer it, I will make note and make sure you get an answer by tomorrow on any questions that you may have. I will say that, according to his report, that we currently have 38 open housing cases. Well, as of February 10th, we had 38 open housing cases. I believe it's lower than that right now. 33 of the cases were over 100 days and 27 were over 200 days.
On that, Cynthia, the number of cases is down,
Yeah,
but the days are up. Probably need to know more about what's taking place there, particularly given the new processes that they have in place. That's on those housing cases. And on the employment cases, we submitted have submitted 43 cases. They've only accepted 39 are now pending. Well, I'll wait till you get to that.
yeah. No, go ahead, go ahead.
I've jumped ahead of page.
Yes. No, we're going. Are you on page 26?
Yeah, 26.
Mhm.
It is with EELC, 43 cases submitted, but only 39 accepted. Is there something, it was the government shutdown is the reason they haven't approved those, or exactly?
Yeah, that might be partial. I believe that number is up some now because I did receive information from Jeremy Sales yesterday that we had 4 that we received credit from just yesterday. So we would have to go back and look at that. But I do know that they did have a period of shutdown as well.
The other thing is the number of employment cases in the last 2 months seem to have spiked. Is there something we're seeing that's driving that spike?
Well, one of the things that I believe is driving some of the spike is Juan and his staff intake. We're receiving and getting more drafted complaints back through intake. And so we get more complaints, draws up the number.
But on percentage basis,
We have more people.
on percentage basis in terms of return of drafted complaints signed, the numbers percentage wise is not much higher than it has been in the past. The previous year, I did my own comparison.
I believe it's the number of inquiries that's coming in. As you may know, that HUD and the EOC intake labor force have reduced to 50%. So a lot of the calls that we receive is that because they have to wait to receive an interview, for example, from the EOC. So they look for other alternatives. So it trickles down to us. And I was going to mention that we have seen a steady high volume of inquiries. And one of my intake officers says the struggle is real, which means that we're trying to keep up with the calls that comes in and work on the complaints.
Any other questions they want to leave with Cynthia, she can take up with Cedric regarding the enforcement report? Okay, back to you, Juan, for education, outreach and intake.
Okay. You have my report before you. I'll be happy to answer any questions. Just like to add a couple of things here. So in the past commission meetings, we have had speakers, and I think we have talked about the immigration and immigrants and that connected to the national origin. I feel like we have started from the beginning, went full circle with the last presentation from Representative Kulkarni, kind of close it well and kind of give, hopefully it gave me and it hopefully give to you a good understanding about this immigration issue and national origin. So in the future, I'll probably see if I can bring some speakers that we can talk about other subjects, for example, disability or race. And so that's the plan. Ms. Cynthia Box said something about the Civil Rights Hall of Fame. So very soon, either probably no later than Monday, we'll send out a press release inviting the public to submit nominations. And we have already decided a location where to have the Hall of Fame induction ceremony. That will be in Frankfurt in November. We don't have the exact date yet, but we're looking for locations and also their availabilities. So we will need your help, that part, so if you know anyone, or just, I'll send you a copy of the press release and you forward to your network. And so we're gonna work with different civil rights groups and anyone who likes to be part of this, but to start receiving these nominations.
The ceremony for the unveiling of the Ben Ruiz poster, where is that gonna be?
That's I have not received details yet. I think it's gonna be here in Louisville, but I will be, once I get receive it, I'll send it to you. It will be on April the 30th.
30, yeah,
Yeah.
like the date was there, but no location.
No, I don't have the location yet.
Any questions for Juan? Then we'll move on to Colt for another report.
All right. You've got my report. As always, Bill and I are moving things along. If there are any questions about the report, I'm happy to take them. Otherwise, I'll ask for a motion in a closed session to discuss pending litigation.
Any questions? Hearing none, can I have a motion for us to adjourn to executive session to discuss pending litigation? So moved.
Second.
Been moved second that we adjourn to executive session to discuss pending litigation. All those in favor say aye.
Aye.
So I asked just the commissioners, the executive director, general counsel, and his support counsel to remain.